All right, folks, it's good to have you all here. Great to see so many familiar faces. This is one of our, I am the faculty director of the Institute of Judicial Administration, IJA. I see our president, Evan Chesler, is here. Good to see him. This is one of our signature events, the Brennan Lecture. It was hatched by John Sexton and Judith Kay, our graduate and former Chief Judge, the late Chief Judge of the New York Court of Appeals. It's an event to honor the state judiciary, which is, in fact, doing most of the heavy lifting for the U.S. legal system. It's also honoring Justice Brennan and the contributions he's made to civil justice. I'm especially proud of it because again, it does highlight the state judges. I am told by my dean, who's my boss, to keep it short. I'm now keeping it short, and I'm turning it over to Roy McKenzie.
Sam is a model faculty member. He does what the dean tells him to do. Those who know started laughing. I know, that's exactly right. Thank you so much, Sam, and it's wonderful to see everyone here this evening. I'm Troy McKenzie. I have the honor and the privilege of being the dean of NYU School of Law, and I'm delighted that you are all here to see the 29th annual Brennan Lecture on State Courts and Social Justice, sponsored by our very own Institute of Judicial Administration. This really is, as Sam said, a signature event for the law school and for IJA. It is our way of highlighting major issues facing the state courts, the court systems that carry the bulk of the responsibility for administering justice, both civil and criminal, throughout this country. We're also proud because this series was established by our alum, the late, great Chief Judge Judith S. Kay, who was a pioneering lawyer, graduate of this law school, and of course, judge and then Chief Judge of the New York Court of Appeals. In fact, recently we were able to unveil a portrait of Chief Judge Kay, joined by her daughter and granddaughter, who live in Colorado, actually. And it's all the way over there in that corner with the Chief Judge wearing a signature red outfit. And I actually love that portrait. It's a fantastic portrait. My main job is actually to introduce the person who is going to introduce Justice Hart. So although I told Sam to keep it short, I'm now violating that by adding another link in the chain. But before getting to Travis, I just want to say a personal note of thanks to Justice Hart. We met quite a while ago because we both had the honor of clerking for the late Justice John Paul Stevens. And the Stevens Clerk Network is, it's good people, and so you know when you see a Stevens clerk, you're going to get quality with a smile. The only thing I didn't do, I didn't wear my bow tie today. I would have done that, but I decided to be more somber today for some reason. Justice Hart is someone who we look to as a real model. Someone who is an intellectual with an academic bent, but also a dedicated judge who we are really looking forward to hearing from tonight. Travis Lenkner. Travis will formally introduce Justice Hart. He is a member of the IJA board, and he is truly a pioneer at the intersection of law, litigation, and finance. His work exemplifies innovation and leadership. He has been recognized by the American Lawyer as an innovative business creator in the legal space. He co-founded a litigation finance firm that was later acquired by Burford Capital and recently rejoined Burford's management committee and serves as Chief Development Officer. He has had an impressive legal journey, beginning with clerkships on the D.C. Circuit for then Judge Brett Kavanaugh, and then at the Supreme Court for Justice Anthony Kennedy. And he also worked as a lawyer, senior counsel at the Boeing Company and at the Gibson Dunn firm in Washington, D.C. and New York. But what really qualifies him to be here this evening is that, he knows where I'm going with this, he is married to an NYU alum, and that's why we really, really like Travis so much. So please join me in welcoming Travis Lenkner.
Thank you, Dean McKenzie, for that kind introduction. I will report back that appropriate homage was paid, and she comes up again in a little bit. So it's nice to see you and all of her and our friends from NYU. On behalf of the Board of Advisors of the Institute for Judicial Administration, it is my honor to be the third person and final person to welcome you to the Brennan Lecture on State Courts and Social Justice, and to introduce this year's featured speaker, Justice Melissa Hart. Before introducing Justice Hart, I want to elaborate briefly on Sam's and Dean McKenzie's note that the Brennan Lecture was the creation of Judge Kay. All of the things that you already know about her have been said already. I will just add one additional note, which is that we have many distinguished judges and other officials in the audience tonight, but among them we have 5 of the 7 members of that court, New York's highest court, the Court of Appeals. So Chief Judge Wilson and Judges Rivera and Singas and Conataro and Halligan. I don't think you sat together, but you're around. We thank you and all of the other judges and other state and federal officials for joining us for this, but in particular, given the history of the lecture, we're very pleased that all of you are here. Yes, that's good. Judge Kay envisioned a series of lectures by leading state court judges on critical issues, and she delivered the first lecture in 1995. Tonight, Justice Hart joins a distinguished list of jurists who have delivered these lectures over the last 30 years. A bit about Justice Hart, first from a biographical perspective. Justice Melissa Hart was appointed to her seat on the Colorado Supreme Court in 2017 and elected to a full 10-year term in 2020. In addition to serving on the court, she is a national leader in our profession. And I'm leaving out a lot of the other things that she does for our profession to focus solely on those that are most relevant to the remarks that she's about to give tonight. She's the vice chair of the Council of the ABA section of Legal Education and Admission to the Bar, and she was a founding board member of Legal Entrepreneurs for Justice, which is Colorado's affordable law practice incubator. As Dean McKenzie mentioned, prior to her judicial service, Justice Hart was a professor. She was at the University of Colorado Law School, where she directed the Byron White Center for the Study of American Constitutional Law. Justice Hart earned her undergraduate degree from Harvard Radcliffe College and her law degree from Harvard Law School, after which she served as a law clerk, first for Judge Calabresi on the Second Circuit, and then for Justice Stevens at the Supreme Court, followed by a stint in practice in Washington, including as a trial attorney at the Department of Justice. Dean McKenzie noted that my wife is an alumna of the law school. I'm obliged to pause here to say that she is also a fellow Guido clerk and a constitutional scholar. And the fact that I am the one here offering this introduction, given all of those points of commonality, has been a topic of some amusement in our household. Be that as it may, one of us is here, and I'm the one you get. So, with her incredible background, Justice Hart had many choices for compelling lecture topics this evening. I do, however, want to pause to clear up one thing that has been going around. Justice Hart is not here to talk about any of her court's recent cases. If you have followed the news over the past several months, you have undoubtedly read about her work in one high-profile matter in particular. a politically charged case that was at the center of our national conversation, literally a huge issue. And I'm speaking, of course, about habeas corpus for elephants. The Colorado Supreme Court recently ruled that 5 elephants at the Cheyenne Mountain Zoo lacked standing to seek a writ of habeas corpus as a challenge to their confinement. She cannot talk about that, okay? Just an unforgettable case, though, truly. Justice Hart's remarks are titled, "Our Legal Institutions Must Change, but How?" You might have seen that title and said, gosh, perhaps she will say that our legal institutions must grant habeas relief to elephants. Again, first, you would be wrong, and secondly, she just can't speak about that. It will remain the elephant in the room. Justice Hart's real topic is far more pressing than my 2 dad jokes, one that was hidden in there, but that some of you did pick up on. It bears on the future of our profession and how our law schools, among other institutions, must chart a course in order to meet those growing challenges. In short, there is an increasing disconnect between much of legal education and the practical skills that are demanded of new lawyers. That disconnect, along with other systemic issues, is widening the gap between the vast majority of people's legal needs and the ability of lawyers and our legal system to meet those needs. All of that has a direct impact on the public's perception of justice and its confidence in our courts at a time when there is very little confidence to spare. These issues are growing ever more urgent, and they require that we rethink many aspects of the legal profession, but as all of the people in this room in particular know, that is very hard to do, and legal institutions are resistant to change. Justice Hart, though, is helping to lead the national conversation on these issues. She is here tonight to help us understand the need for change and to lay out potential reforms along with some of the obstacles that those reforms face. For my part, my work has focused on how resources can be introduced to a historically closed and undercapitalized profession, and on technological advances and regulatory changes that can democratize legal service delivery and increase access for all. So I share all of your interest in this important topic and very much look forward to hearing Justice Hart's perspective. With that, it is an honor to introduce, here to present this year's Brennan Lecture on State Courts and Social Justice, Justice Melissa Hart.
All right, well, Travis, you said that you were the third and final person to welcome people here tonight, but I'm going to contradict you and say I'm the fourth and final person to welcome you here tonight. And also, thank you for your introduction. It was really a pleasure to talk with you last week. I didn't know, well, I guess you mentioned about the NYU semi-connection. I didn't get into NYU Law School when I applied, so I think you're in good company. I want to start by saying I've been grateful to the Institute for Judicial Administration since I attended their baby appellate judge school, as it's generally known, as a baby appellate judge in the summer of 2018. I learned a huge amount, and I met friends from all over the country who have continued to be friends and sounding boards as we have grown into our roles as, I don't know if we would be like toddler or teenage appellate judges. I was very fortunate to participate as a faculty member in the program last summer. And again, I was amazed by what this program offers to the judges in our country, our state court judges, who I think we really need to recognize decide most of the legal appellate questions, who are developing most of the details of statutory construction and constitutional law. in this country. So the work this institute does is really remarkable. So I thank you to Allison, to the fellows who provide so much each year, and to Sam. Sam, in putting together this talk, I spent many hours reading your book, Beyond Elite Law, Access to Civil Justice in America. It's an amazing collection of really important work. I recommend it to all of you. It's really quite remarkable. Thank you for everything that you do. Troy, I'm grateful for your friendship, for being part of the JPS clerk community. I think there are 4 or maybe even 5 of us here tonight, which is pretty remarkable. And for your leadership in the academic world. So, and I have to say, in preparing for this, I watched a number of previous Brennan lectures, so I was prepared for the 4 introductory speeches. So, to turn now to my actual remarks. I came here tonight to talk about 3 questions that I and many others believe are urgent in our profession. Before I turn to those questions, I want to pause and say how important it is as we try to solve any hard problem to remember the importance of recognizing our diverse backgrounds and experiences and what they bring to the table, and that we maintain a commitment to inclusion and belonging as we try to improve our legal institutions. These values are so important. I do not believe that we can solve the problems we confront if we put them behind us. This is something that I am reminded of every day in the roles I serve. The roles have gotten me thinking about the challenges facing our legal system today, and it's something I think we need to continue to say. As Travis mentioned, I spent 17 years as a full-time law professor, and I continue to teach as an adjunct. I'm a justice on Colorado's Supreme Court, and I'm the vice chair of the ABA Council of the Section of Legal Education and Admission to the Bar, which is the accrediting agency for law schools in the United States. Having just said all of that, I want to be extremely clear that I am speaking here today absolutely on my own behalf and not on behalf of the council, my court, or either of the law schools at which I have taught. But I've certainly learned a lot from serving in each of these roles. And what I have learned has left me certain that, as the title of my talk suggests, our legal institutions must change. And it turns out that I'm not the only person who thinks so. In August 2023, the Conference of Chief Justices and the Conference of State Court Administrators passed Resolution 1, establishing the Committee on Legal Education and Admissions Reform, called CLEAR. CLEAR was tasked at looking at 3 challenges that leadership of state courts have become increasingly concerned about. What law schools should be doing to ensure that graduates are ready to practice law, how states should appropriately assess minimum competence for admission to the bar, and how we can incentivize and enable new lawyers to fill the most needed areas of practice. In a landscape brief it released last spring, CLEAR said that it would, quote, work to catalyze high-impact reforms from state Supreme Courts aimed at further aligning bar admissions and legal education around bringing practice-ready, competent attorneys to meet the legal needs of communities around the country. Think about that goal. the committee aims to catalyze reforms from state Supreme Courts that will align bar admissions and legal education around a specific goal, bringing practice-ready, competent attorneys to meet the needs of legal communities in their states. That is a huge mission. I've spent a lot of time pondering which of CLEAR's 3 questions, legal education, bar admissions, or access to justice, is the biggest. One way to answer that would be to acknowledge that 2 of them, questions about legal education and bar admissions, are in pursuit of the 3rd, the ultimate goal of meeting communities' legal needs. I do think it is essential to keep that fact in mind always. But another way to think about the size of the questions is to put them in what I think of as their own biggest terms. So, CLEAR asks, what should law schools be doing to ensure that graduates are ready to practice law? It sounds straightforward, but I think the question is actually at least 2 much larger questions. 1, what is the purpose of law school? And 2, could we, and who the we is its own question, radically change what at least some law schools look like? On the first question, since joining the Council on Legal Education and Admission to the Bar, I've had many law deans and professors say to me that graduating practice-ready lawyers is not the job of law schools. Law schools are supposed to teach students to think like lawyers. We train them in analogical reasoning, the common law, the Langdellian case method. Perhaps they take a clinic or an externship, have a summer job to develop a sense of their practice interests, or even to land that postgraduate job. But the 3-year law school curriculum that became standard in the US in 1906 has been focused primarily on developing content knowledge and critical thinking. The notion of focusing on the work a student would do after they left law school as part of the teaching curriculum has not been how most law schools have focused their curriculum. And consider the ABA accreditation standards. Their curricular requirements are actually very minimal. It was only in 1974 that legal ethics became a mandatory course for ABA accredited law schools. The only mandatory course other than legal writing. The accreditation standards now also do require students to complete 2 legal writing courses. And in 2014, the council added a requirement that students complete 6 credits of experiential education, which can be a clinic, a simulation class, or a field placement, so a very open-ended experiential requirement. And that's it. Those are the curricular requirements. I have to confess, and I don't know if any of the rest of you would be willing to admit this, but before I joined the council, I assumed that contracts, torts, criminal law were all ABA accreditation requirements. I was surprised to learn that none of that was required for graduation from law school. But it has become, obviously, as we know, standard. But it's not required. The council is currently considering increasing the experiential learning requirement to either 9 or 12 credits. Response from within the law schools has been largely extremely negative. In some ways, that's unsurprising. Accrediting requirements are a burden. Effective experiential education can be expensive. I'm actually guessing that for most of us in this room, when we attended law school, there was only one clinic, legal aid. I didn't do it, and I didn't do an externship. I'm not actually sure that externships were available when I attended law school. But today, according to my weekend research, Harvard has 24 clinics, and NYU has many more than that, over 30 by my count currently available, which is great. And externships have become standard. So the needle has moved in these past 3 decades to a place of recognizing that one thing students can get out of law school is practice experience. What CLEAR is asking is whether that is something that students should get out of law school, and if so, how much? In some ways, that question being asked by the Supreme Court justices on the CLEAR committee is quite similar to what law schools say in responses to the council's proposals on accreditation. They ask, explain to us why these are relevant to minimum standards for practicing lawyers. Because ultimately, that's what accreditation standards should be. They should be tied to minimum standards for practicing lawyers. And that's a fair question, therefore, to ask of an accrediting body. So I think this brings me to the second big question that undergirds CLEAR's starting question. Could we radically change what at least some law schools look like? For example, the ABA accreditation standards currently permit brick and mortar law schools to apply for a variance to also offer fully online legal education. And at this point, about 12 law schools do offer a fully online program. But the standards do not offer an option for a fully online law school that is not connected to an already existing brick and mortar program. There may be good reasons to maintain this rule. Once a school is fully online, it is difficult to know where it is actually based, in the United States or outside, for example, and potentially to evaluate the standards it maintains. But not everyone agrees with this proposition. In 2024, the Indiana Supreme Court amended its admissions rules to permit graduates from non-ABA accredited law schools to be admitted specifically because they wanted to allow graduates from Purdue Global Law School to petition for admission to the bar in Indiana. California and Connecticut also admit Purdue graduates, and California has long permitted non-ABA accredited law school grads. I believe North Carolina is poised to admit Purdue Global graduates as well. So one possibility is simply that states choose for themselves whether they want to open up their admissions practices to remove the accrediting body from the process. My sense is that few states are excited about this option. It feels too exploratory. There's something safe about relying on an accrediting body. So that opens up another possibility. The Council on Legal Education and Admissions to the Bar considers changes to its accrediting standards. Changes have been made in, changes at the margins more than big changes, but with regard to accrediting a fully online law school, that's actually happening. The actual accreditation hasn't happened, but considering the possibility is happening now. Like most legal institutions, the council moves very deliberately, so it's taking time, but it's happening. What about other possible changes, though? For example, the standards right now require students to complete a course of study of not less than 83 credit hours, with not less than 64 of those hours in regularly scheduled classroom sessions or direct faculty instruction. That means essentially that a student can, if they are aggressive about their coursework, complete law school in 2.5 years. As we know, though, 3 years is standard. Are we certain that more than 2 years of bottoms in seats classroom time is what developing lawyers need to best serve the public? It's a question to ask. Are we certain that that's what lawyers need? Is it possible, just possible, that a model, for example, that incorporated 2 years of substantive legal education with 1 year of apprenticeship would do better? Or at least that permitting law schools to offer an option of that type, a 2-year curriculum, and here I'm going to transition to bar admissions with a lengthy parenthetical beforehand, is something we should explore. Okay, now the lengthy parenthetical. One of the reasons that change in these areas is hard is that there are a lot of actors with deeply vested interests. To say that law schools could, and perhaps should, start offering a 2-year option is to remove 1/3 of their tuition base. We've avoided that for a long time by creating full semester externships. I don't know how many of you are young enough in this room to have done a full semester externship, but they've come up in recent years, for which students continue to pay law school tuition. They go work elsewhere. I've got a nod back there. They go work elsewhere, but they pay the law school for that privilege. I don't have confidence that students will be willing to pay full year tuition for an externship. If it's worth discussing a model that shortens law school and then requires apprenticeship for bar admission, it will require confronting the economic realities of that change for law schools willing to do that. Okay, so how about bar admissions? With only a few exceptions, state Supreme Courts in the US require, in addition to graduation from an accredited law school, completion of a bar exam to become a licensed attorney. We do this for, I believe, a fundamentally laudable reason: consumer protection. Attorneys have so much power simply by virtue of our greater knowledge and our understanding of legal rules and of the working of a complex system that it is important to ensure that we meet some minimum standards of competence and professional ethics. But to come back to my framing of trying to put CLEAR's questions in their biggest terms, is the assessment of minimum competence that most states use, the uniform bar exam, actually testing minimum competence? I just got a lot of no's. And if not, what do we do about that? I am guessing that a majority of the people in this room took a bar exam. Probably not the UBE, because it was established in 2011, but something similar. I'm going to skip over my next sentences because you all answered it. I don't believe it tests minimum competence. And I think that belief is what's motivating CLEAR to examine other possibilities. There are some really fascinating options already operating, from the very bespoke Daniel Webster program at the University of New Hampshire School of Law, a really extraordinary program if you haven't heard of it, that in many ways is a residency during second and third year of law school, but which suffers from being hard to scale. It only graduates less than 20 graduates each year, and it's hard to scale. To diploma privilege, which Wisconsin grants to any graduate of the University of Wisconsin or Marquette Law School on completion of a degree. Diploma privilege has not caught fire among state Supreme Courts, I think because of concerns that what law students are learning in law school is not enough to ensure that they meet the standards for consumer protection we feel bound to uphold. And the immediate response to that can certainly be, well, neither does the bar exam. I'll come back to that. Oregon this year began what I believe is the first modern apprenticeship admissions process. Through this process, a graduate must complete 675 hours of supervised work, lead at least 2 client interviews or counseling sessions, oversee at least 2 negotiations, and produced at least 8 written work products. The portfolio that an applicant then submits will be reviewed by a bar examiner, and if found adequate, will qualify that applicant for admission. I, like many other state Supreme Court justices, am watching with great curiosity to see how the Oregon experiment goes. What I find intriguing about Oregon's new approach is that it acknowledges the importance of, first, client engagement, second, written work, and third, supervision, and I hope feedback from an experienced attorney. By spreading this supervised work out over a year, the Oregon plan tries to make it cost-effective. One of the huge challenges in thinking about how to better evaluate the readiness of a new lawyer to practice law is that multiple choice standardized tests are relatively cheap to grade. Whereas evaluating client engagement and written work is relatively time-consuming and therefore relatively expensive to grade. Given that the cost of the bar exam is already a stressor for law graduates, finding a balance in this mix is not easy. While this conversation is going on, the National Council of Bar Examiners is rolling out the next-gen bar exam, similarly seeking to respond to concerns about whether the bar exam we have actually measures minimum competence. And while CLEAR is asking questions about whether alternatives to admission should be considered, and Supreme Courts around the country are pushing back very hard, being pushed very hard by law students to look at alternatives, there are realities that will make change here just as challenging as change on the legal education front. We have all become very accustomed to the portability of a law license. As individual states start to look at individual bar admission standards, licenses will necessarily become more localized. Can we overcome this? Of course we can. But like the costs of legal education, it's a challenge we need to acknowledge will make change complicated. And the rollout of the next-gen bar examination revealed what many believe is a fundamental divide in conversations about minimum competency. Initially, the NCBE announced that it would no longer test either family law or trusts and estates. State Supreme Court justices from many states responded with astonishment. 98% of total cases are filed in state courts, more than 66 million cases a year. For most people, if they ever interact with the court system, it will be with a state court. And a huge number of those cases are either domestic relations or probate and estate cases. So for many state Supreme Court justices who oversee that reality, the notion that the bar would focus on federal civil procedure, federal evidence, contracts, criminal law, torts, business associations, constitutional law, and real property seemed like a remove from what the citizens in their states were facing in court on a daily basis. State Supreme Courts pushed back, and the NCBE will be adding family law back to the next-gen exam, along with a number of skills-based evaluations that I have been told by recent graduates, and I'm looking over at my former law clerk, Jake, who have sampled the test, are much more like the practice of law than our current bar exam evaluates. I think trusts and estates is still a question, but what is interesting is that active conversations are occurring between the state regulators, the courts, and bar administrators about how best to determine what minimum competence looks like. I'm not convinced myself that I have yet heard a solution about how we know that a person has achieved minimum competence to represent clients. To me, this may be where CLEAR's first two questions come together. Does law school need to have a residency requirement? Is some amount of supervised client interaction necessary for a law student to become a licensed attorney? Or can we assess this question on a timed exam given over a course of just a few days? I'm taking the speaker's privilege here to put those questions out without answering them myself because I am truly still just puzzling through them. I want to turn now to CLEAR's third question, the motivating question. We are facing a crisis in the provision of legal services in this country. I want to start by trying to define this crisis, which is actually remarkably hard to do. I really appreciate CLEAR's statement of it in their landscape document, which I noticed that NYU provided as a CLE material. It's a great read. I highly recommend that you take a look at it. They say, quote, "The causes and the solutions to the justice gap are multifaceted, as are the strategies that will bridge it. Across the country, one root cause is clear. Far too attorneys are in place to assist clients with serious legal challenges." I think that expresses it. However, when they have tried to shorten that statement, CLEAR has tended to say that we have a shortage of public interest or public service attorneys. And I'm sure that you here at NYU would argue with that. You are the preeminent public interest law school in this country. You know that many, many law students want to go into public interest and public service work. But the problem is what is missing is not applicants to the ACLU or the Environmental Defense Fund, or the Brennan Center, all wonderful organizations. The lawyer shortage is in public defenders and district attorney offices in more rural areas around the country. And it is among lawyers willing and able to charge rates that people can afford to help them with their basic legal needs: family, probate, estates, housing, consumer, public benefits, and criminal. I think it is not only fair, but very important to start calling the work that these lawyers do, even when they do it to make a living, public interest work or public service work. But it will require a change in mindset, particularly for that second group of attorneys. And for that first group of attorneys, DAs and public defenders in rural communities, we are facing a challenge that is not at all unique to the legal field and that is getting worse year over year. So what do we do? And why does thinking about legal education and bar admission relate to it? I think there are a few answers to these questions, and none of them is easy. Let me start with filling public offices. DA and public defender positions in rural communities. A few states have looked at providing financial assistance, either tax incentives or loan repayment assistance, to try to encourage recent graduates to go to rural communities. In Maine, for example, the rural tax incentive has focused on incentivizing up to 5 lawyers to live in and serve rural communities. But it hasn't focused on government lawyers. And although the state offers the program to up to 5 lawyers, only 2 each year have taken advantage of it. In South Dakota, the state pays lawyers who commit to 5 years serving in rural parts of the state and who graduated from the University of South Dakota 90% of 1 year's tuition each year. At some level, those are incredible financial incentives, but they're not really making a dent in the problem. In Colorado, we've taken a different approach, not so much a financial incentive as an experiential incentive through what we call the Greater Colorado Law School Experience. We're really struggling with what to call outside of the metro area because not all of it is rural, right? I'm sure everyone has this in their states. It's not all rural, but it's not the metro area. Our program it's run by our statewide Access to Justice Commission, and it places students in communities outside of the Denver metro area in their first year summer, and then if they want to come back in their second year summer to try to develop roots in the community with the thought that that's really what's important. It's not so much about the financial incentives, it's really about finding community. But even that, it's 8 or 10 people each year, and as those communities are shrinking, the problem's not going away. And so that challenge, the reality of our shrinking rural communities and small metro communities, and then also the extraordinary cost of law school and the attendant legal debt that graduates are burdened with. We haven't figured out how to solve that problem. Turning then to the access to justice gap, that is the failure of our profession to serve the basic legal needs of people. This is something that has been discussed by academics for years now. Again, I want to refer you all to Sam's excellent book. attorneys for corporations are widely available. The very wealthy are also able to find representation. The very poor are somewhat able to find representation, although 50% of clients seeking representation from legal services organization are turned away because of conflicts of interest, lack of available resources within an organization, or restrictions on what legal services organizations are able to offer clients. The really, really deep gap, though, lies between the poorest among us and the small number able to pay for attorneys at what we call market rates. For this population, are we failing to help law students or new lawyers see how they might make a good living providing what is fundamentally a public service? Offering legal representation in areas where people need representation that those people can afford to pay and that could support a legal practice. I believe that we are. So how do we change that? What do we do to show attorneys how to make a good living doing good work representing people who need that help? One possibility could be to change law school graduation requirements, and CLEAR is exploring that question. And it has been talking to the Council on Legal Education and Admission to the Bar about what that would look like, since for the time being, at least, that is where change would come from. But change could also, again, come from the state Supreme Courts themselves. State Supreme Courts could do, for example, what the New York Court of Appeals did not that many years ago, and require pro bono service for admission, or require some other additional forms of experiential training not required by the ABA for admission to the bar. The question that should be kept front of mind, I believe, is to what end? Do pro bono requirements actually end the access to justice crisis? Or do we need to find ways to rethink the economics of providing legal service, either through non-legal service providers, such as Colorado's new licensed legal paraprofessionals, who can provide legal assistance in a wide range of family law cases, or by, again, helping lawyers learn how to run their practices differently. Here, I will circle back to the first question, and I promise I'm almost done. About 10 years ago, as Travis mentioned, I got involved in the then nascent affordable law practice incubator movement. I'm sort of guessing that most of you are wondering what an affordable law practice incubator is. The idea really exemplified in the Justice Entrepreneurs Project in Chicago, and I like to think in Legal Entrepreneurs for Justice in Colorado, is to bring together lawyers who are committed to running practices representing human beings or small companies and charging affordable rates and predictable rates, and running their practices with those goals in mind. The incubator will provide a safe space for the lawyers to figure out how they want to run their businesses, teach them client management, advertising, billing, all of those skills of running a practice that we don't teach in law schools. In Colorado, we've had attorneys in the same year doing criminal law, immigration law, labor, and small business law. Instead of being solo practitioners with all of the anxiety that brings, they benefit from the support of that community. I harbor no illusion, though, that affordable law practice incubators will address the access to justice gap our country faces. I offer the idea as a question about how we are doing legal education, whether that's something that should be happening after law school or whether that's something that should be happening during law school, and whether we could offer opportunities to students committing service committed to serving communities in need through models we have not yet explored. Thank you so much.
Super. I want to talk to you some more about these ideas. A terrific, insightful, provocative talk, Justice Hart, and epitomizes what the Brennan lectures are about. Thank you very much. We have time for some questions.
Am I supposed to stay here or go there?
We can sit together if you like. Yes.
If someone has a
Identify yourself.
My name is Cecelia, and I've heard two of you, or the most important for me, were two of the emphasis which you made on the competence of the lawyers and the absence of emphasis on how actual judging is done. And once you said that 98% of the cases are state cases, then I understood it. Because my problem, I have a tremendous problem with the system which you are trying to fix, was evidenced in the federal procedure, where to my astonishment, instead of adjudicating my lawyer's argument, and my lawyer was extremely competent because he was at NYU, instead of doing that, the judge did his own lawyer and awarded victory to his own argument. And when I tried to sue a whole bunch of judges, I'm not going to go into details, for fraud, the judges, federal judges, defended themselves by the self-given in Pearson against Stray, absolute immunity in cases where they act on the bench maliciously. So, yeah, so my question is, right,
Let's take some other questions.
but I have a question. Adding sua sponte argument to the criteria of judicial misconduct, wouldn't that fix an awful
We are not
problem?
focusing on judicial misconduct. Thank you.
Well, but I am.
I am. We'll talk off the record.
Well, the judge spoke about how the community is being served by the
So
professional.
we do
And
one
I'm
thing,
telling
we do
you,
one thing at a time. We can talk off record. Sure.
Lawrence Mandelker, class of 1968. Thanks. Lawrence Mandelker, class of 1968, which means I'm at this almost 57 years. You've covered so much. And preliminarily, I want to say this problem wasn't created in a day, and it won't be solved in a day. But there is something that might be a model, and I may not understand the model correctly, and if I get it wrong, forgive me. But I think I have it substantially correct. How are doctors trained? They go to medical school. They graduate from medical school. I think medical school is 4 years. I'm not sure. Then they go to a residence program at a teaching hospital. They are paid less than the going rate. They work longer than the going rate hours. But they learn how to be a doctor as opposed to learning how to be medicine. And then they take their qualifying examination in order to be licensed as a doctor. Could this be a model for the law school? 3 years of law school, then we have to create an institution that could sponsor and pay for residencies, and then figure out how to do the qualifying exam. Thanks.
Well, I don't know, can I just talk really loud?
Yes.
Okay.
Do you want to take?
I'm very loud.
Hello?
Now I'm even louder. I mean, that's why I intentionally use the word residency. I and many others have wondered about how to incorporate a residency into legal education. I think one of the challenges, and I say this in part based on my frustrating experience trying to raise money for Colorado's Affordable Law Practice Incubator. where I discovered that it's extremely hard to raise money for lawyers, is that it's very hard to convince Troy, yes, you appreciate that too. People are unconvinced that the provision of legal services is a public service, whereas people are, I think, comfortable that the provision of medical services is a public service. And so those residency years are easier to fund within medicine than I think they would be within law. And I think that's a challenge we would need to overcome. But if we could get over that, I think that's an important answer.
So on that side? Okay. Stu?
Thank you. Since I graduated in 1965, I trump my comrade here. I wanted, what I've heard today is an analysis from the top down. How do we tweak the existing system to make it better? Is anybody working from the other end and saying, ideally, if we could forget about all of the problems of funding and everything that will impede change, if we start from fresh and say, first of all, how do we analyze what the needs are, in your explanation about domestic law and taxation and some of the other estates and trusts is a good one to show that a lot of what ordinary people interact with, parking violations and other things, and that's perhaps where we should start. Where are the greatest needs? And how would they be best served? I think your paraprofessionals in Colorado is a good idea, and that might be a way to do that, so that in this age, do we have a lawyer just doing the fact analysis, and we have another lawyer who does the research and helps him put the facts and the research together. So what I'm suggesting is a look at this from our current technological capabilities, AI, computer research, whatever, and a user-friendly kind of approach to what are people's needs. Construct a fantasy situation that, as politically improbable as it may be a good idea just to present and show to people.
I entirely agree. and there are lots of people out there in the tech world who are doing that. So you brought up parking violations. That's one of the areas where there has actually been a lot of innovation specifically in the tech world on literally mobile problem, like legal solutions to parking violations. States have not responded well. Anxiety about unauthorized practice of law is very strong, and I think you also mentioned political barriers, and I do think you can, whether you describe it as political barriers or institutional barriers, both are at play. I think there, as I said, I think there are a lot of actors with very vested interests in the systems that we have, and that's why change is slow. It doesn't happen quickly. But I love your idea of starting from the ground up and saying, what would a system look like if we imagined no rules, and we asked, how could we meet people's needs, turn off the noise of what we already know, and started from there. I think that would be a really interesting way to do it. I fully admit, already having been a lawyer and for 30 years, I already know how hard it would be for me to do that. Like, I would get in my own way. And I think that's one of the challenges, is that we would all get in our own way. But if we could find a way to do that, I think that would be great.
We have time for one more, but I want to just point out that Chief Judge Rowan Wilson is here.
yes.
And he will be the next Brennan lecturer. One more from that side, anyone? I'm not seeing any questions. In the back.
Yes, I'd like to go one step perhaps further in the deconstruction. I think we need to examine what is the practice of law, because it's so much more than walking with the client into a courtroom. It's the person who walks into your office, wherever, whatever venue that might be, and says, "Help me." And you have to first figure out what that person's problem is. So it goes so, maybe you never get to court. What about, the kids who are leaving law school and doing 2 years of document review? Are they practicing law? What about the people who are working in a state legislature who do or don't have a law degree and are writing the rules for what we're doing? I mean, I can tell you from experience, some of them can barely construct an English sentence. So I think we really have to go further in analyzing where we are.
There are many strands to this problem.
It's
many solutions that
it's
have been
huge.
worked on. Yes, it is.
Well, and I want to flip how you started and say, I do think states have not come up with a good way of describing what the practice of law is. There are lots of things we prohibit non-lawyers from doing that would be incredibly helpful, that aren't the practice of law. So, for example, in federal proceedings, your sister can come in and hold your hand. That's fine. In a state court, she can't. Why not? That's not the practice of law. That's just providing emotional support. But crossing the bar, you can only do if you're a lawyer. So why haven't we developed more sophisticated ways to think about what the needs are of the people coming into our courtrooms and how we can meet them? And the answer, I think, is because it's hard. I think that's the answer.
Well, thank you for provoking us, thinking about this issue.